Good afternoon and welcome. My name is Alexander Rufus-Isaacs. I'm also known as Zan, and I'm the chair of this program about the influence of the English common law in California. Before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. And this program will be available for replay in a couple of days' time in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Company. A couple of upcoming events we'd like to notify you about. Firstly, next Wednesday, September 21st at the Maybourne Hotel in Beverly Hills, we have the 10th annual Litigation Awards Dinner as we honor Matt Rosengart of Greenberg Traurig and the Honorable David J. Cowan, Supervising Judge of the Civil Division of the Los Angeles Superior Court. The link to the register will be posted in the chat shortly. Then on October 3rd, we have a program about the extradition of Julian Assange from the UK to the USA. Our panelists are two lawyers who represent Assange. We have a former senior FBI officer and a former federal prosecutor. They'll be explaining the current extradition proceedings in London and discuss whether Assange should be extradited, and if he is, whether he can expect a fair trial under the 1917 Espionage Act. You can watch this program live on BHBA's YouTube channel, or you can register and use the link that's going to be put up in the chat in a minute. I'm now going to introduce the participants in today's program. I've known about section 22.2 for some years, but this program really only came about because of the enthusiasm with which they have embraced the idea, for which I'm most grateful. All four of us were born in the UK and at various times started rolling west until we hit California, following incidentally in the footsteps of Sir Francis Drake, who landed near Point Reyes, north of San Francisco in 1579 and claimed the territory, which he called Nova Albion, for the English crown. How different things may have been if the first Queen Elizabeth had decided to establish a colony here back in those days. Our speakers, Judge David Cowan has not only led the civil division of the LA Superior Court through the uncertain waters of COVID, but has also pushed the recent expansion of the Beverly Hills Courthouse, for which we're most grateful. Judge Cowan was born in London. He lived there until he was 14 when his family moved to California. He is a graduate of Hastings and Columbia University, and he practiced as a lawyer in LA for 17 years before being elevated to the bench in 2014. Edd Capewell is a graduate of Cambridge University, where he achieved the distinction of a double first, which is similar to summa cum laude. He was then admitted as a barrister in England and practiced at 11 King's Bench Walk in the Inner Temple for 9 years until he moved to California 3 years ago. He did an LLM at UCLA Law and joined Loeb Loeb, where he is an associate in the litigation department, handling complex commercial litigation, intellectual property, entertainment, and real estate related matters. Michelle Wedderburn was born and raised in London until her family moved to Kingston, Jamaica when she was 10. She still has family in London and is a frequent visitor. She is a graduate of Abraham Lincoln University and Skidmore College. She's been licensed to practice law in California since 2012, represents healthcare providers of the law offices of Stephenson, Acquisto, and Colma. And prior to that, she practiced family law, immigration law, and landlord-tenant law. Also like to give a shout out to our good friend, Judge Glenda Sanders of the Orange County Superior Court, who participated in a number of our meetings. And as always, I would like to thank Kathleen and the members of the BHBA staff who made this possible. Before I hand over to Michelle, who is our moderator today, I would like to thank the Beverly Hills Bar Association, the British American Bar Association, and the Orange County Bar Association for supporting our program. If anyone has any questions during the program, please put them in the Q&A function, and if we have time, we will try to answer them. And lastly, we will be using a PowerPoint presentation throughout the program, and there is a PDF copy of the PowerPoint in your materials. So with that, over to Michelle, and I hope you enjoy the program. Thank you.
Thank you, Alexander. I really appreciate that lovely introduction. So I'd like to start by acknowledging the passing of Queen Elizabeth II. She was an extraordinary woman. She lived an extraordinary life, and all I can say is rest well, rest in peace. So I thought it appropriate to say something about her because she was an incredible person, and we won't see another person like her for a very long time. So we're here today to discuss how the English law remains relevant to your case. I'm actually going to start out by reading section 22.2, and I won't be doing a lot of reading, but I think this deserves to be read out. It's very short. The common law of England, so far as it is not repugnant to or inconsistent with the Constitution of the United States or the Constitution or laws of this state, is the rule of decision in all the courts of this state. So that's really what we're here to talk about today. So how did this come about? Well, in 1848, gold was discovered in the Sierra Nevada. That's amazing. So when gold was discovered, everybody rushed this way to find their fortune, to find their fame, to make their name, something. Well, it so happened that at that time, the United States and Mexico were in a war. And less than 6 months after the discovery of the gold, there was a treaty, the Treaty of Guadalupe Hidalgo, and that concluded the war between the two countries. At the same time, people kept coming, and a constitution was soon adopted. And shortly after that, there was a legislature that was elected. And one of the first things they did was to declare that the common law of England would become the rule of decision in the courts insofar as it was in harmony with the federal constitution and the laws and constitution of the state. So, Ed, what does adopting the common law mean?
Well, the statute talks about adopting the common law of England. If we could move to the next slide, I think. And I guess I just want to break that down slightly. The first point to make is that within what is now the United Kingdom, there are a number of different jurisdictions. There is England and Wales, and Scotland and Northern Ireland are separate jurisdictions. So I think the statute must be talking about the law of England and Wales, which is essentially, at least the common law, is the same. Scots law is slightly different, and Northern Irish law is much the same as English law so far as the common law is concerned. And the second point to make, I think, is the question about what the common law actually is. There's a broader meaning of what the common law is, which is, as the slide says, just all of that law which is made by judges. And there is the narrower meaning of the common law, which is the common law versus equity, which obviously is relevant to the question of, in California at least, and under the federal constitution, it is relevant to the question of whether you're entitled to trial by jury or not. But I think the statute is talking about common law in the broadest sense. And it probably also includes the common law as it was influenced by some of the ancient English statutes. For example, the second version of Magna Carta from 1225, which is still on the statute books in, at least a small part of it is still on the statute books in England. And the statute of frauds from 1677, for example, which influenced the question of form in English contract law. So it's the common law broadly, it's all of that judge-made law, which built up with the deciding of cases based on specific facts. And I think the other issue is, well, at what point in time are we talking about the common law? The common law obviously doesn't stand still. New cases are decided based on existing precedents. The principles are developed incrementally, but nevertheless they are developed. There is a lot of English law which has been significantly redrawn by statute in the 20th century, such that there are large areas of law where the common law has effectively ceased to have any real meaning whatsoever in English law. But as the slide says, there's still a lot of English law today, which is still judge-made, which is still common law. Contract law, the basic framework of contract law, significant concepts like interpretation of contracts, the implication of terms, the illegality doctrine, and so forth. The law of tort, the law of trusts, which obviously on the narrower meaning is equity rather than common law, but nevertheless is still mostly judge-made. Administrative law, what was codified at the federal level in the United States in the Administrative Procedure Act, is still entirely common law in England. And some basic principles of the legal system, like what is called in England legal professional privilege, which encompasses what the English call legal advice privilege, what we would call here attorney-client privilege, and litigation privilege, which is similar to work product protection. And then I put in brackets the law of evidence and the mode of trial, as we'll talk about later. One of the very significant changes which happened in England in the 20th century, in civil cases at least, was that almost the entirety of the common law of evidence was swept away and was not replaced by any statutory code of evidence. The common law right, if it was a right to a jury trial in a civil case, was almost entirely abolished. So I think when thinking about the common law of England, there is the question of what is it and when do we look at it? And I think there are arguments in favor of looking at the law as it stood in 1850 or around 1850. But there are also arguments in favor of looking at English law as it exists today, because the modern English cases are still using some of the precedents and some of the same common law principles that were established by around 1850. And so there can be flexibility on the time in terms of when one is looking at what the common law actually is. Maybe an exercise purely in archaeology, but it may also be a question of looking at what English law is today. If we could go to the next slide, please. So where can
I was just about to ask you about that, Ed. I was, you know, a lot of times right now we've got 64 people in this the CLE class, and I know, maybe not you, but there are a lot of times when people start their searches on Google. So I was just about to ask you, where do we find this body of law that where we might actually find answers to our motions or oppositions, or just something new, different, something that helps us? Where do we find this information?
Right. Well, I mean, this slide has a number of links for where you can find the information, and freely as well, without needing subscription to the UK versions of Lexis or Westlaw. The website bailey.org is a great resource for finding English case law, and there is a link on the homepage of Bailey to a page called Leading Cases by Subject, where you can look at, for example, a whole long list of cases in, for example, contract law, which are founding precedents from the 18th century onwards, I think. There's a new website run by the UK National Archives, which is also putting all English case law online. And you can also look directly to the Supreme Court website. The Supreme Court was the successor to the House of Lords, which was previously the highest appellate court. And you can see there recent decisions of the Supreme Court and do your case law searches that way. The other initial place to look is Holsbury's Laws of England. That one does require a Lexis subscription, but that's a massive encyclopedia of the principles of English law. And then if you are interested in doing some historical archaeology, there's a link there to a set of reports of cases in the courts that existed before the Judicature Acts in the 1870s, and I'll talk about that a little bit later. And you can find lots of interesting reports there of old cases from the 19th century. And the other thing, of course, you can do is to ask your local friendly English barristers for help in finding some of this stuff, and we'd be very happy to help you.
That would be you, Ed, and that would be you, Alexander. So there you have it. So, you know, the English common law at this point, we're looking at about 1,000 years of law, which is incredible when you think about it. And so, you know, situations that happen today probably are the same kind of situations that happened, maybe not 1,000 years ago, but certainly 200 or 300 years ago. So here we have a case now, the Delamire case, which is a case from 1722. I had to do a little math because, as you know, lawyers are not the best at math, but the first time I counted it, I got to 400. And then I said, no, that's not right. And I said, okay, no, 300 years ago. This case is 300 years ago, which is amazing that it still has relevance today. So can you tell us about this poor chap, this chimney sweep, and the relevance of that it has today, and maybe how we can use this case?
Right, yeah, if we move to the next slide. So this case, there's a very short, at least to our modern eyes, report of this case. It involved a chimney sweeper's boy who, lucky for him, found a jewel in the course of his work, and he takes it to a goldsmith, and the goldsmith's apprentice rips him off, and he has a look at the jewel, and he pockets the jewel, and he gives him back the ring or whatever it was that it was set in. And so the chimney sweeper's boy goes to the court, and he says, well, he says two things. And firstly, he seeks to establish the basic proposition of law of finders keepers. And the court says, well, not quite. But more importantly, for our purposes, the court instructs the jury, because it was a jury at that point in time, that if the original jewel was not produced, which it wasn't, as far as we can tell from the report, then the jury should presume the highest value of the lost jewel against the party that didn't produce it, so here the goldsmith. And as I say, it's a very, very brief report of the case, but that basic principle that if a party is responsible for the loss or suppression of evidence, then the court is entitled to draw adverse inferences against them, either to assume that the matter in question is of the highest value, or to otherwise draw negative inferences about that party's evidence. That's something which is still cited today. I can think of commercial cases where a party sought lost profits, and they say, well, we're entitled to a fair wind in the assessment of damages, because but for the defendant's conduct, we would have been able to win this contract and win that contract. And it was their actions that mean that we can't lead evidence to show that that would definitely have happened. And equally, it's been used more recently in the phone hacking cases is another example, and in the more recent Wagatha Christie trial, and that basic principle, even though it was established in the first part of the 18th century and is based on a very short report of a case and instructions to a jury, is a thread which is carried through the common law to the present day.
Yeah. So the word repugnant, I've thought about that word quite a bit in the last couple of months. We've been working together, putting this program together, and I have fallen in love with this word and want to find a way to include it in just about everything I do. So Judge Cowan, going back to that word repugnant. So can we move to the next slide, please? Thank you.
Thanks, Michelle. So let's, before I get into definitions, and good afternoon, everybody, Ed talked about, and Michelle's read the statute about, well, common law is part of California law. It's in our statutes. So why don't we hear more about British law if it's part of system? And so I think that the quick answer to that is really that the common law has been codified for the most part, to the extent it's relevant. So we don't really often get into whether something is or isn't repugnant to the common law, because it wouldn't be in the statutes if it was repugnant. And so that really kind of takes out a big chunk of the discussion, but fortunately, not all of it. It's always going to be the exceptions, right, that keep us busy. And so then we look to, well, if it's not in our own California statutes, does it still have any bearing? And what's tricky about this is, as Ed alluded to, is that what the heck is the common law? Is it what existed in 1850? Is it what exists now? And interestingly, the citation to this case, Schmier versus Supreme Court, 78 Calap 4th 703, which deals with somebody who sued the California Supreme Court, saying, listen, stop only publishing certain decisions. The common law is much broader than that. It's all of those hundreds of years of tradition where judges looked at specific situations and came up with the applicable rules of decisions as specific to that, those facts. That's what we all learn in law school, right? And so this Mr. Schmier said, listen, why is California restricting the common law just to what you appellate judges think are the most important cases that you choose to publish? Why isn't it everything? Because that's what's built up these traditions and rules and experience over the years. But guess what? This is where we get back into repugnance. The common law can be displaced by statute or by the law itself, as Ed said, being itself developed. Common law is about those certain facts, and every case is different. Facts change. So Mr. Schmier lost his case because California rules of court displaced the common law by setting forth various rules relating to why published decisions should be the applicable common law on which we, at least as lawyers and judges, can rely.
No, Judge Cowan, I always say when we know better, we do better. And I tried to think where I heard that, and I figured out, I think it was Oprah. So, are there some laws that you explained to us about repugnance and how something that is repugnant wouldn't even make it that far, because repugnant is going to be a very high standard. But are there can you give us some examples of some of the common law that just simply does not work for us here in California?
Yes, I think that the biggest example is that, as you indicated, California used to be part of Mexico. And so guess what? Our marital laws are community property based, not based on the laws of England. So I think that that's probably the biggest example where California chose to do something different, and the community property laws treat husband and wife, two spouses, equally. And of course, the traditions in England and other places previously was quite different. And so I think California was probably way ahead of British law in that respect. And if you talk about repugnant, this is something that they are mutually incompatible, I would say, is really the definition of repugnance. Another example is discovery, according to the Schmier case. Ed could probably talk about this more, but I suppose traditionally, trials, there was no issues about discovery. Things could come up, there could be surprises at trial, but now we have a statutory basis for learning the facts before we get to trial. A third example I think is significant. You'll see here the Blevins case about the law of England, common law of England, that every man is bound to keep his beasts with his own close within his own land, or otherwise he or she's going to be held responsible. But interestingly, the common law changes depending on circumstances. And of course, in California, we have a huge central valley with livestock and with cows and other animals. And the livestock industry probably wasn't interested in being found liable if one of its cows or other things got out. And so we were displaced. But of course, then California said, well, we're going to still keep the common law. We're going to change it just in certain counties. And so as we'll get into later, what the common law is, as opposed to what is a statute, can be a long inquiry.
And let's talk a little bit about, if you would, about water law, because that seems to be just something that was completely incompatible with the English common law. We have such problems with water in California as it is. Can you tell us anything about the riparian rights under the common law and how it, translated to our law now?
So I think that I'll start with this sort of point, which is that we all know that it rains endlessly in London. I spent my childhood inside because it was always better to be home than walking outside. But of course, in Southern California, it never rains, right? And so
they even made a song about it.
Exactly. So our rivers, if we have any, or the Colorado River that we rely on, is not exactly the bucolic rivers of England. They are not. The Colorado River is not full, and so this, if any area, frankly, is of potentially huge significance, it's whether the old common law riparian rights rules, whereby the adjoining landowners to a river got the rights to use the water. That is definitely, I'm no water rights expert, but as I understand it, that is a huge controversy because I think that some of these rules still are applicable. The statutes are incomplete. And then when we talk about the statutes, going back to repugnance, I didn't mention this on an earlier slide, but the statutes are assumed to include common law unless it's so clearly not the case. So even if we do have statutes that deal with water rights, query whether these riparian rights issues still apply. And then one final point about this is that, again, we originally got rid of these riparian rights rules because, as Michelle indicated, people needed to use that water to get the gold. And they were trespassers and did not own the land that adjoined the rivers. And so those rules, those riparian rights rules, really did not apply. So we got rid of them. But then subsequent cases, as you'll see here, for example, the Pleasanton Valley Canal Company case says we still do have riparian rights. So again, this is a lot of grist for the mill. It's going to keep the courts and you busy. So let's move on from, that's really my sort of summary of that issue for right now.
Thank you, Judge Cowan. So Alexander, you're up. It's your turn. Can we talk?
Thank you, Michelle.
Thank you. So let's talk a little bit about the Cattsburg case, which actually was a fairly recent case in 2002. Yeah, we've moved on a little bit. We're now talking about the due process violations in this fairly recent case, and the Magna Carta comes up again in this case, this very recent case in 2002. Can you tell us about that?
Sure. Next slide, please. Before we do move on, I just wanted to add something to Judge Cowan's remarks about water law, is that one of the substantial differences between English and and US law is the right to fish, which is very important to some of us who are passionate fishermen. I've heard it said that the reason why many people migrated to this country is so they could fish where they wanted to. And, you know, that is indeed the rule here, is that people do not control the right to fish in a river, which is very much an important property right back in the UK. Here, the issue is much more about stream access. But once you get into the river at a lawful point, you can fish all you want. And it's part of the wonderful freedom it is of living in this country, as opposed to having some sort of game warden looking over your shoulder all the time. Catsburg, I wanted to find a couple of examples of how these principles that Michelle and Ed and Judge Cowan have been talking about apply in practice. I like very much what Judge Cowan was saying about the traditional element of the common law, because that's really what it's about, is that is there a, when you're looking at a particular point of law, is there a tradition of such a principle? And this is what we look at. It's malleable, it's flexible, it comes, it goes. But here are two recent cases which I'm going to talk about, which I think illustrate this principle quite well. Catsburg, 2002, California Supreme Court case. The background facts briefly are that Professor Catsburg was a professor of radiology at UC Davis. He was also the head of the department. And there was an issue involving some misallocated funds. There was no suggestion that he had personally taken them. There was something about some rebates from manufacturers and that they hadn't been applied to the correct way. And he was removed as the head of the radiology department. And he stayed on as a professor, but he was very upset at being removed in these circumstances, and he felt that it reflected poorly on him. And there is a principle called the liberty interest which can be found in the due process clause of our Constitution. I think it's Article 1, Section 7, and it basically says that if an at-will government employee is removed from their position in circumstances where they're basically made to look bad, they're entitled to a hearing so that they can put their side of things and to clear their name. And that's what Professor Catsburg wanted to do. He sued the regents of the university for damages. And that's where the problem arose, because the university said, you have no right to damages for a violation of your liberty interests under the due process clause. And they won on summary judgment. They said, we offered him the opportunity to have a hearing. He declined it, and that was his only remedy, and therefore we win. The Superior Court agreed with him, and the Court of Appeal agreed with him, and the matter made its way up to the California Supreme Court. The California Supreme Court affirmed. They held that an action for damages was not available for two reasons. Firstly, they said there's no evidence from which to infer an intent within the due process clause itself to afford a damages remedy. They looked very closely at the historical documents behind the passing of that particular clause, the debates and various other things. And they didn't find any mention in there that there was an intention to create a damages remedy. And they also went and looked, and they found that there was no common law history from which to infer an intent to provide an action for damages. And what they said was this: they say, in considering evidence of an implied right to seek damages, we believe that it's appropriate to examine common law history from which we might infer an intent to provide an action for damages to remedy a violation of that provision. So I think the principle is very clear. They're going, we're going to look at common law history and we're going to see if we can find any evidence. And if we can, then we are going to infer such a right. So they went ahead and did an investigation. They in fact relied on a 1996 New York case called Brown versus State. And that's entirely a legitimate thing to do, because apart from Louisiana, virtually every other state in the Union has English law as its bedrock in the same way that California does, and they have a similar, code sections to 22.2. New York, it goes back much further. I think their constitution is from 1777, and the Brown Court observed. They say the prohibition against unlawful searches and seizures originated in the Magna Carta and has been part of our statutory law since 1828. The civil cause of action was fully developed in England and provided a damages remedy for victims of unlawful searches at common law. So in other words, they are finding that for unlawful searches, yes, there is a damages remedy, and you can see I found a rather nice visual on the screen of a medieval search and seizure. There's some very unpleasant acts going on here. The plaintiffs could indeed sue for damages. Would anybody like to hazard a guess at the settlement value of this case? It would probably be quite substantial. I think it would certainly be entitled punitive damages. There's a gentleman down at the bottom who's stabbing a dog, so that would increase things a lot. But but at the same time, they went and looked and they found no equivalent provision for damages for a violation of due process. And on that basis, the California Supreme Court made this distinction. They said, yes, there is a remedy for damages for unlawful search and seizure. No, there is not for violation of due process. And I think it's a classic example where the common law was the decisive influence in that decision. Next slide, please.
Zan, when I looked at that picture, I thought it was a still from the Game of Thrones, because that's exactly what happens in that show. But before you talk about that next case, I do want to just remind everyone that the name of this class is How English Common Law Remains Relevant to Your Case. And I think this next case really embodies that principle, because this is a case from the Ninth Circuit in 2021, which you're going to discuss in a minute. And, I remember the Turtles in this song because as a child, I was forced to listen to whatever music my parents wanted to listen to. So I am very familiar with this song. I love it. I'm sure I have a copy of it on my phone. But the bottom line is this case embodies the title of this class, that the common law is wholly relevant today as it was from whenever. So with that, please take it away.
I love the album art, which I was able to find with all the happy turtles singing along. This particular decision, Ninth Circuit 2021, the latest in the series of cases brought by Flo and Eddie, which was a corporation formed by the lead members of the Turtles. They held the rights to their songs, including Happy Together, a very complicated area of copyright law, which really concerned whether or not digital and satellite radio stations had to pay the owners of pre-1972 songs for playing their songs through their stations. And it's complicated because there's this patchwork of state rights, of federal rights, and then these different obligations between terrestrial and digital stations. And what the court did in these circumstances, and I'll explain why in a second, is they went right back to the 19th century and to see what the origins were of whether or not there was a right of public performance. Public performance is whether or not you, as the owner of a song, can you stop somebody else from performing that song in public or from broadcasting it to the public? Or more to the point, can you insist on payment if somebody does that? And they came back and said, no, there is no right of public performance in music that they could find. California passed its copyright statute, its first copyright statute in 1872, and it included in there the phrase exclusive ownership. And really the outcome of the Flo and Eddie series of cases depended on whether or not the term exclusive ownership in that statute included the right of public performance. because under the 1972, or actually 1976 Act, it didn't actually provide a right for any owners of any sound recordings pre-1972 to be paid. So you had to go back. And the district court ruled that exclusive ownership did include a right of public performance, but the Ninth Circuit disagreed. They explained California has this deep-rooted common law understanding of copyright protection based on English law, and that there was nothing to suggest that this understanding had been changed when the word exclusive ownership appeared in the 1872 copyright statute. And they go on to say, California courts did not start deciding cases on a blank slate, nor did the California legislature draft a copyright statute based on just its imagination running away. Rather, they inherited the common law tradition. English law, at least before the founding, remained relatively silent on public performance rights for songs. But we can learn much from the sound of silence. And essentially what they did is a historical review and found that as a matter of tradition, that there is no tradition of including a right of public performance in this concept of exclusive ownership within copyright, and therefore they declined to construe that exclusive ownership did include a right of performance, and that's unfortunate for Flo and Eddie. So with that, I'll pass it back to Michelle.
Thank you, Zan. That was a really good explanation there. So we're going to move to the next slide, if we may. And we're going to talk about the right to a jury trial. So Ed, you being the right to a jury trial in England, we'll start with that. You being the most recent arrival in the United States, California specifically, can you tell us some more about the right to a jury trial under the English common law?
Yeah, I mean, as it exists today, I'll talk about this a little bit later, there is no right to a jury in a civil trial, but certainly the idea, at least, and it's pretty much lost in the mists of time, but the most common idea is that the right to a jury trial was established by Articles 39 and 40 of Magna Carta. It's almost certainly the case that that was not intended to establish a right to a trial by jury. And at least at that point in time, if you wanted to, in the 13th century, if you wanted to seek damages against somebody, you're more likely to be looking at trial by ordeal or trial by battle. But nevertheless, the idea grew up that Magna Carta established this common law right to trial by jury. And that was then received into US law and is obviously in the federal constitution and is in the constitutions of nearly all of the states, including California. So that's where it came from. Judge Cowan's going to talk about where it is at the moment in California, and then I'll say a little bit about where it's gone in England.
All right, thanks.
I was
Ed.
just about to hand it over to him, but thank you for doing my job for me.
All right, well, thank you both. If we can go back to the previous slide, page 15. Thank you. All right, so as in history certainly is there that England did have at some point a long time ago, apparently, jury trials in civil cases, but no longer. So I think this is significant because as we started off this program talking about, well, what year are we exactly talking about vis-a-vis the common law? And there's no question that when we look at the California cases that I'm going to briefly try to run through, that the California cases look to whether, as it's quoted here, whether there was a right to a jury trial in common law actions that were triable by a jury in 1850, but not in suits in equity that were not triable by a jury in 1850. And so, well, okay, that's when our California Constitution and these, as I believe, are right around this time. But why are we now looking at what happened in 1850? Should we look at the time when it was in 1850? Well, that's what the law, California law, indicates we should do. And in fact, as the nationwide biweekly California Supreme Court case from 2020 makes clear, there's no question that the jury trial right is tethered to English common law as of that date. And in fact, there's even, this keeps on going, even as of September 8, earlier this month, in ZF Micro Solutions versus TAT Capital Partners, again, which is a case relating to a fiduciary duty claim out of the 4th Appellate District, looking at supposedly at the historical, this is purely a historical question. But let's go to the next slide, because I think that's what the cases say, but I think there's a little bit more to it. We have, of course, we need to, as many of you are aware, what is the gist of the action? Is it a purely statutory claim? Is it a quasi-statutory? Is it a common law claim? This 1941 case from California Supreme Court is a good one, and gets into these issues, and it indicates that the jury trial issues goes beyond just looking at statutory claims, but is extended to cases of like nature. So we don't just look at precisely what was going on at that time, but also similar types of claim. In other words, we need to start analyzing what exactly went on at that time. Going again back to law school, is it law? Is it equity? Well, how can we further define that? If we can go to the next slide. Is this something that's purely damages? Is it going to result in a money judgment? Or are we more doing balancing, like on an injunction, which would be, of course, the traditional role of an equitable court of a judge? And so I think one other way of looking at this, not just at the history, is seeing which side does that fall under. The nationwide case dealt with false advertising claim, an unfair competition claim, clearly statutory rights that did not exist in 1850. Court holds no right to a jury. Significantly, also, if we go to the next slide, we could bump 2 slides in the interest of time. We get to this case on page 19, LaFace, which deals with the Private Attorney General's Act, which is of course a critical claim that is widely pursued in our courts. This court recently, earlier this year, again indicates statutory right dealing with enforcement of labor code provisions and the like, no right to a jury trial. But we also need to look at our California Constitution and our U.S. Constitution, and what do those indicate? Well, we still have the jury trial right is obviously highly valued, has a place in our own traditions, and is stated in our California Constitution, and also provided for in the 7th Amendment to the United States Constitution. Interestingly, in the nationwide case, our Supreme Court indicates, notwithstanding what the federal courts are doing in their courts, in California, we're not going to be, even though the U.S. Constitution might provide for a jury trial in those federal courts, and in California, we're going to look to issues of, is it more regulatory, or is it more damages based? And if it's more on the regulatory / balancing issue, there's going to be no right to a jury, notwithstanding what goes on in the 7th Amendment, which is not implied to the states through the 14th Amendment, would say in federal court context. Let's keep on going on this because there's an interesting twist here, which is that going back to that issue of repugnance, as you'll recall, it talks about, is it incompatible with both the California Constitution and the United States Constitution? So we have an issue here, at least with vis-a-vis some of these new statutory claims. Well, it may be that it is consistent with one constitution, but not consistent with another constitution. So then how does 22.2 apply? Is there repugnance? It needs to satisfy both. What happens when the two constitutions differ? So that's an issue still to be decided. Another related issue, as leaving aside federal versus California, we also have different states, obviously. Delaware is a prime example of a lot of litigation in its courts of chancery, courts of equity, a lot of serious cases relating to financial issues that might be something that would be the subject of a jury trial in California, would not be heard in, would be heard rather in a chancery court in Delaware. We have a right to a jury trial in California. Is that going to be compromised in any way if the matter is heard in chancery courts, business disputes heard in Delaware? What is, as you see on page 23, what is the effect of jury trial waivers when it comes to matters that may end up in Delaware? Are we going to enforce those or not? Again, should we or are we governed by what happened in England in 1850? Apparently, that's no longer the law there. Why are we deciding issues between two states based on these old principles? That's what the cases indicate we need to do. But again, for purposes of how is this relevant to how litigation today is, we still need to wrestle through these different rules of different jurisdictions. I'm going to turn it back to you now, Ed, or to Michelle rather, for purposes of what's happening in England at this point.
So, all right. So Ed, we're going to go to slide 28 at this point in time. I think they're just a little bit off right now. So slide 27. Thank you. All right, Ed. This was surprising to me. Jury in England.
Yeah, so
very interesting.
it is an interesting difference between the two systems now, and as Judge Cowan was just talking about, the California cases say, well, we have to look at what the situation was in 1850, and the English court system in 1850 was an extremely confusing mess, and there were a number of courts that were common law courts, and then there was the Chancellor's Court, which was an equitable court. And you had to make sure you used the right form of action and start your case in the right court. Otherwise, you would end up in serious difficulties because the common law courts could not dispense equitable remedies, whereas the Chancellor's Court could dispense both equitable remedies and legal remedies like damages. What happened in the 1870s, both in England and in fact in the US, if you look at the California Code of Civil Procedure, it says, I can't remember the section now, but towards the beginning, there is one form of civil action. And that's been there since 1872. And that was around the same time that the English courts were fundamentally redrawing themselves and seeking to abolish all these confusing distinctions between common law forms of action and equitable forms of action and so on. And so far as the jury is concerned, the jury was something that you would get in a common law court, or you would have got at least in or around 1850. But over time, and it started in 1854, as the slide says, a statute said that the parties could effectively choose to have trial by a judge alone, even in a common law cause of action. And over time, the idea of having cases, civil cases we're talking about, tried by a judge alone proved to be very popular. The process was accelerated by the onset of the First World War, which made it very difficult for juries to be empaneled. And shortly after the First World War, there was a statute that abolished the right to trial by jury in most cases. And then the Administration of Justice Act 1933 made that more complete. The last type of case that was regularly tried to a jury, or where there was a right to trial by jury in the civil arena, was in defamation, libel, and slander. but that was removed finally under the Defamation Act of 2013. So this common law right, which is held to be sacred on this side of the Atlantic, was effectively binned in England, and is certainly not much missed amongst civil practitioners. Most would be absolutely horrified if you suggested to them they'd have to try their breach of contract case to a jury. And so it's an interesting example of the way in which this idea of looking at what the English common law was in 1850 it is not at all reflective of what the English common law is in England today. And as Judge Cowan said, it seems odd in some ways that we're looking at how in a long gone court system certain types of action were tried in order to identify in the 21st century whether they should be tried in that way today.
Yeah, that's interesting. I'll tell you, the word that really jumped out to me here was the word abolished, because that's such, again, another strong word. I mean, it, you know, it to me, it implies as though it was something bad, and now we're abolishing it. But that's just, that's probably not a completely correct interpretation. What I'd like to talk about right now, if we can, and I understand if everyone doesn't want to get involved in this, and it can be just a brief discussion, is what I'll call DEP 1 and DEP 2. So as we know, we were all transfixed to the televisions over the summer when we watched the televised trial, you know, between Johnny Depp and Amber Heard, knowing what had happened some time back with the DEP 1 trial. We have two countries which basically have used the same kind of law for a long time, and we have two completely different results here. One was tried, the first case in the UK, of course, it was tried before a judge. The other was tried before a jury. And as I pointed out, they made in the second trial, they made great effect in using something I've heard called the Darvo technique, which is, let me get this right, it's when you deny, attack, and reverse victim and offender. So we know what happened in both of those cases. Does anyone care to say anything about DEP 1 and DEP 2? What happened here? One was a trial before the judge, one was a trial before a jury.
I can step in here. I actually had some firsthand experience as counsel for News Group in DEP 1. It was my responsibility to get orders requiring various witnesses to attend the trial. Interestingly, they attended by video, and the video was located in the conference room of the Beverly Hills Bar at 9420 Wilshire Boulevard. And for several days, a procession of witnesses would come into the conference room. There was a live video link with the High Court in London, and these witnesses would testify and would be cross-examined by counsel who were in London. And eventually, Mr. Justice Nichol, who was the judge presiding the case, issued his judgment. As far as I can tell, I didn't follow DEP 2 that closely. Much of the evidence was the same. Many of the same witnesses testified, and so far as I can tell, there wasn't a great discrepancy between the evidence that was presented in DEP 1 and DEP 2, but the decisions were the opposite. And I feel that I have great respect for juries. They all, most of the time, get it right. But one weak spot in the jury system is where celebrities are involved because of the unfortunate reliance or whatever you want to call it that people have of the way in which they sort of place celebrities on a pedestal. And I feel that that had a very unfortunate effect in DEP 2, and that DEP 2 was the result very much more of some emotion and who they liked and who they didn't like, rather than in DEP 1, where Mr. Justice Nicol issued an incredibly detailed and well-reasoned decision explaining why he ruled for the defense, going through each of the incidents and finding, in his view, that there is substantial probability that these incidents occurred and that therefore the son did not defame Mr. Depp. And I think it's a very unusual. There is a difference in the burden of proof. In England, the burden is on the defense to prove truth as a defense, whereas in the US, the difference is that the plaintiff must prove that the statement is false, but you would have thought that that would have been had the opposite effect because of the difficulty of proving that the difficulty of proving truth in the English proceeding rested with the defendant news group, whereas and they managed to discharge that and show that what happened, what they say happened, whereas in Virginia the opposite happened, and Mr. Depp was able to satisfy the jury that the statements that Ms. Heard made were false. I don't know. I'd love to hear what everybody else has to say about it.
I would just have one footnote to add, which is that in the Virginia case, there was a demurrer, or whatever the equivalent of a demurrer is in Virginia, on the basis that the issues were res judicata because of the English case. And that was unsuccessful, in part at least because the judge looked at what English defamation law was, including this question of the burden of proof, and said, well, it's significantly different to what it is here, notwithstanding the shared common law origins. And I think there are arguments that can be made that that was something of a misunderstanding of English law as it exists now. But that's a very interesting example of where shared origins have moved in slightly different directions. But nevertheless, it's still potentially relevant to look at those shared origins in the common law of England to see how we've both got to the points that we are at now.
I would do not want to comment on the case, but I would ask that you take a look at page 29, and which is sort of apropos of this discussion about inconsistent results, and go back to, again, Justice Holmes, who stated in the common law, here we have him, picture of him, book, stated the life of the law has not been logic, it has been experience. And again, so I go back to what we discussed at the beginning, that the common law developed, as he says so nicely here, the felt necessities of the time, the prevalent moral and political theories, institutions of public policy, avowed or unconscious, and so on. And so, you know, I would suggest that we look at this, because this is the gravamen, as it were, of what we're discussing here about the common law, and that its positivity is that it can change. When we talk about tradition, it's not about wanting things the way they used to be. It's rather about looking at how things develop over time. So I think that I recommend going back to somebody we learned about in law school, Justice Holmes here, provides some useful answers. Thank you.
Thank you, Judge Cowan. So, you know, we're winding down now, and my question to you is, why should we rely on the common law now? So we can take a yes, we should rely on that, or on the common law, excuse me, or no, we really shouldn't rely on the common law. So I'll leave it up to you, but I'm thinking that I think Ed is the person who would like to discuss why we should continue to rely on the common law.
Yeah, well, I will be very brief because we're slightly running over, but I think there are obviously areas where the common law has been overtaken by statute or by events or by the different way in which public policy has evolved in California as against England. But there are still these shared roots across many important areas of private law in particular. And so I think there definitely is value in looking at English law, including the current English court's interpretation of the common law, in the areas that I mentioned earlier, where the common law still rules, as it were, because the principles are the same. And I think it's worthwhile for different common law systems to look at how they have each dealt with knotty issues in the law, because they are using the same tools, and they're coming from the same origins, and they're using the same principles to try and solve these difficult questions. And so I think to that extent, the English common law is still relevant, as well as the historical sense in which it's relevant to, for example, the question of right to a jury under the California Constitution.
And Judge Cowan, what do you think about that? Do you think that we shouldn't rely on the English common law?
Well, I think I'm going to follow our law, and as a judge, I think it's important for me to follow the rules. And I think that the 22.2 states it well in one sentence. I don't think I could improve on that. I would just say that it's about values. It's about being reasonable, and I think that that's what we try to do in the courts, and to deal with each case one at a time. Every person is different. Every case is different. And to me, that's why I would argue that the common law is still relevant.
Yeah. Well,
And if I could just chime in as well before we end, I think the big takeaway from this program is, to anybody who is confronted with an issue where there is not a clear answer under existing California law, you should absolutely look at the common law traditions, English common law, the common law of other states, and Section 22.2 is there to support you when you cite that law, saying this is important. And there are many cases still of first impression. If you look at the number of requests made by the Ninth Circuit, the California Supreme Court, saying, please, decide this point of California law. In other words, a matter of first impression. And in those circumstances, but also, in regular courts, we can cite English common law for this tradition that we stand on many, many, many centuries. And I agree with both Ed and Judge Cowan, is that, we stand on all of these years, and it stands for reasonableness, it stands for common sense, and it's a great tradition.
It would be, I think, very difficult to argue against the common law. So that was always going to be a very difficult position to defend, but no doubt there is someone out there who will defend that position, but not here today. So I'd like to, we're going to conclude now. I'd like to, unless someone has something else to add, I was actually going to say, I have it highlighted here in my notes, and then Judge Cowan said it before I did. I said the life of the law has not been logic. It has been experience. And by the way, that wasn't written by Justice Holmes. That was written by Oliver Wendell Holmes Jr. before he became a justice, when he wrote that book in 1881. So he's been in preparation for the whole thing for a long time. So that was him before he actually became a justice with the Supreme Court. So any other questions or comments or anything? And I'm going to tie this up in a minute.
From me.
Yeah, doesn't look like it. Let me see. Let me just check if I have any questions outstanding here. I do not. Thank you. Thank you very much, Sita Beauchamp. I want to, first of all, thank our panel today, very well versed and distinguished. We spent a lot of time together over the last few months, and I appreciate all the extraordinary knowledge that you shared. So I'd like to also thank the Beverly Hills Bar Association and Kathleen Battle, who's been manning the PDF for us, and and also Ben Futternick, who is a research attorney who put together this wonderful PDF that everyone can now print off and use. And I'd like to thank the Orange County Bar Association, as well as the British American Bar Association, which is, by the way, it's a jolly fun group. And I certainly look forward to meeting at the King's Head in the future now that COVID is somewhat behind us. And finally, I'd like to thank my firm, Stephenson, Acquisto, and Coleman. I'll be back to work soon. So we started this program. We started this program talking about someone who was a grandmother, Queen Elizabeth II, Queen Elizabeth II, I should say. And we're going to end it talking about my grandmother, who lived in England for most of her life. And whenever we'd leave her house, she'd say to us, "Ta-ta, and I love you." I can't say I love you to all of you, but I will say ta-ta. So thank you very much. This has been very informative, and I look forward to the next time. So thank you, everyone. Goodbye. Have a great weekend. Thank you.
Thank you, Michelle.
Thank you, everybody.
Thank you.